So welcome today to today's webinar, the impact of coronavirus on employees. And this one specifically looks at some of the common issues that we're seeing around the country, including job losses, stand downs and dismissals. My name's Carly Hansen. I'm the Sector Sustainability Coordinator at Community Legal Centres Queensland. And before I get started, I'd like to acknowledge the traditional owners of the land on which we're holding today's webinar. In Brisbane, where we are, they are the Turrbal and the Yagara peoples. I wish to pay respect to their elders, past, present and future, and acknowledge the very important role that Aboriginal and Torres Strait Islanders continue to play in our society. As today's webinar is being viewed by people throughout Queensland and throughout Australia, I'd also like to pay respect to the traditional owners of the land throughout the country and extend a very warm welcome to any First Australians who are listening in today. So today we're really fortunate to be joined by Alu Arteta from Caxton Legal Centre. I'll let Alu talk a little bit more about herself when I hand over to her in just a moment. But I'll just do some housekeeping quickly before we start. So today's webinar is being recorded and we'll have the recording available to download hopefully later today or tomorrow for you and for those who have missed out on joining in live. The PowerPoints and other materials have been emailed out to everyone who registered, so they're also available on our website, and I'll upload them in just a moment to the handout section of the GoToWebinar control panel. As we usually do, we'll hold questions to the end, but please do feel free to type your questions in as you think of them, and we can deal with those all together once Alu's finished the formal part of the presentation. You can type those into the chat box on GoToWebinar, or you can press the button that looks like a hand and we'll see those hands come up and we can unmute you if you've got access to a microphone. We'll also be doing a couple of polls today, so we'd appreciate your participation in those. They'll just pop up on the screen and we'll give you those instructions so that you can have some engagement with the content. And now I'll hand over to Alu to get us started. Thanks so much, Alu.
Thank you so much, Carly. Hi, everyone. Thanks so much for joining us today in the webinar. As Carly said, my name's Alu Arteta. I'm an experienced employment lawyer, and I also practice in anti-discrimination and human rights law at Caxton Legal Centre. I've recently started at Caxton. It's been a wonderful experience so far. I'm really glad to be joining you all today to guide you through some of these issues that we're experiencing at the moment. With the continuing impact of the coronavirus outbreak on all facets of our lives, I do hope that everyone is going the best that they can in the circumstances. I'll also let you know that prior to starting, today I've woken up with a bit of a sniffle. So if there's a random mute during the presentation, I apologise. I'm either clearing my nose or having a little bit of a cough. So I apologise in advance for that. I'd also like to acknowledge the Yagara and Turrbal peoples as the First Nations custodians of the land of which we work. We pay our respects to their elders past, present and emerging, and acknowledge that the important role Aboriginal and Torres Strait Islanders continue to have in our society. As this presentation is being viewed throughout Queensland and interstate, we also pay respect to the traditional owners of the land throughout the country and extend a warm welcome to any First Australians listening to this presentation. For the disclaimer, so the information today provided in this presentation is for professional development and education purposes only. It is not to be relied upon as legal advice. Hopefully this pop-up stops coming up. So before we start, we'd like to do a poll just to gauge your knowledge of employment law. So Carly will bring that up in a moment.
Okay, hopefully you can all see that. So please just select which option suits you best. So around your knowledge of employment law and redundancy. Are you an expert? Do you have some knowledge, or do you just have really no idea? I'll leave it open just for another 10 seconds. Some good responses coming through. That's great. All right. I might close that poll now. So thank you so much. looks like we had about 73% of people with some knowledge, which was our biggest area, but 25% no idea and only 3% expert. So I think we'll launch the next poll now on stand downs. So again, if you could just type your response or select your response that best matches your knowledge. Are you an expert on stand downs? Do you have some knowledge or no idea? Okay, great answers coming through. So for this one, looks like fewer people have knowledge around stand downs. So we've got about 40% with some knowledge and close to 60 with no idea. So thanks for that one. I'll launch the final poll now. So we're now looking at dismissals. What sort of knowledge do you have around dismissals? Are you an expert? Do you have some knowledge, or again, not really any idea about this area of the law? Okay, great, getting some responses in. So I'll just give you another couple of seconds and I'll close that one down as well. So 74% with some knowledge, 21% no idea, and 5% expert. Thanks so much for participating. Over to you again, Alu.
Thank you, Carly, and thank you everyone for your responses. I'm not surprised by the responses to stand down, given the usually in this context it usually happens when there's cases anyway reflect when there's been industrial action in some instances. So our coronavirus situation that we're dealing with is certainly novel, and we might see a few cases come in relation to challenging stand downs in the next couple of months. Today I'll cover redundancies, stand down and workplace dismissals in the context of COVID-19. I will not be addressing employee entitlements or information on JobKeeper or job seeker payments, but I have provided some relevant links under the useful links slide of this presentation. Also, I will be generally covering employees who are national system employees and employed on a full-time or part-time basis under the Fair Work Act unless otherwise specified. For state government employees in Queensland, please look at the relevant legislation that covers state government and also industrial agreements, of course, that covers state government employees. In our own practice, we have received a significant number of queries from people who have been stood down, made redundant, or have been dismissed for reasons related to COVID-19. These issues ordinarily are complex, and there is further added complexity given the unprecedented situation that we find ourselves in. I do hope that by the end of this webinar that you feel equipped to identify issues relating to redundancy, stand downs and workplace dismissals arising out of this situation that we find ourselves in. Just provided a roadmap of what we'll be covering today. So that is redundancy, what includes the genuine redundancy, what is a stand down, and when can employees be stood down, considerations that employers may take into account prior to standing down employees and or making redundancies, the options for employees who have been stood down or dismissed, and support for employees who have been dismissed. For redundancy, this usually occurs when an employer does not need a job to be done by anyone or when an employer becomes insolvent or bankrupt. In the context of the coronavirus outbreak, a redundancy may occur for one or a few reasons, and this list, of course, is not exhaustive. So when there has been a downturn in demand for services, sales, or production, when the business relocates, when a business closes or becomes insolvent or bankrupt, or when duties previously performed by a position is reallocated or absorbed by other employees. The requirement to consult with employees about a redundancy only occurs when an award or enterprise agreement applies to an employee and that award or enterprise agreement contains a requirement to consult around major workplace change. This obligation to consult can include, for example, so I've just pulled and summarised the obligations under Clause 8 of the Hospitality General Award. So that can include giving notice of the change to all employees, discussing with the employees and their representatives the changes, the likely effect of the change on the employees, and any measures that the employer has taken to avoid or reduce the adverse impacts of the changes of the employees. And these discussions must be commenced as soon as practicable after a definite decision has been made by the employer. The employer must also provide written information about all the relevant information about the proposed change. So that also includes the nature of the changes, the impact on the employees, and any other matters likely to affect the employees. The employer must consider any matters raised by the employees or their representatives about the changes. For a genuine redundancy, if an employee is made redundant, it must be a genuine redundancy in that operational changes in an employer's business mean that they no longer require the job to be done by anyone, and the employer complied with any consultation requirement set out in an award or enterprise agreement to consult with an employee or their union about the redundancy, and it would not have been reasonable to redeploy the employee within another area of the employer's business or to a company associated with the employer's business. If so, an employee must be paid appropriate notice, redundancy pay, and any other entitlements owed to the employee. And that could, of course, include long service leave. If the redundancy is not genuine, an employee may have recourse to bring an unfair dismissal claim, and we'll look at an example of this a bit later on. Stand down. So an enterprise agreement or employment contract may include a stand down provision or provide that additional requirements are to be met by the employer, and this can include any consultation or notice requirements that an employer must meet before standing down an employee. If the terms of an enterprise agreement or contract of employment provide for the standing down of employees, the employer will generally need to rely upon those terms to effect the stand down of the employee. Where an enterprise agreement or contract of employment does not include the right of an employer to stand down an employee, the Fair Work Act provides a default right to stand down employees for a certain period, and I've provided the relevant sections there for you to look at. For employees who are stood down, they are not entitled to any pay during this period in accordance with Section 524, subsection 3 of the Fair Work Act. For those employees who are on annual leave or parental leave or other authorised leave or absence, those employees are not stood down for the period of their leave or absence. Importantly, an employee's continuity of service is not affected by a stand down, and entitlements based on service, such as annual leave or long service leave, will continue to accrue during the stand down period. I've provided section 524 in full just so that you can see it set out there. And in terms of what I mentioned earlier, I have seen a number of cases under subsection 1A and 1B, I think very little cases, and we'll be seeing this in the next few months, certainly in terms of stand downs in the context of COVID-19. So essentially, this is broken down into three parts. An employer may stand down employees for a period where the employee cannot be usefully employed because of a stoppage of work, and for any cause for which an employer cannot be reasonably held responsible. So in this context, we're looking specifically at section 524, subsection 1C. Firstly, an employer may only stand down an employee under the Fair Work Act if they cannot be usefully employed. A downturn in work or demand for services does not meet the requirements of stand down, where employees can, for example, be redeployed to another positions, or modifications are made to the usual system of work. As to whether an employee cannot be usefully employed will be a question of fact to be determined in considering the circumstances of the employer. It's likely that the Fair Work Commission, in deciding any of these cases, will defer to a large extent as to the employer's judgment as to what would be useful for the business. An employer may seek to demonstrate that they had regard to other duties the employee could have done outside their substantive position, and or whether there were any redeployment opportunities available at the time. Secondly, the inability to usefully employ the employees must be because of a stoppage of work. We have seen plenty of current announcements from large employers ranging from Qantas to Myer in terms of these businesses who have told their employees that they're stood down for a period of time. In our view, a stoppage of work occurs when a business is temporarily forced to close, whether this is a total or partial shutdown directly due to government restrictions in relation to COVID-19. For example, employees at the local pool are stood down by the local council due to the enforceable government direction for the closure of non-essential local government facilities. Or when a proportion of a workplace is required to self-isolate, which does not allow for the remaining employees to continue their work. These are likely to be considered a stoppage of work. In the latter situation that I've just described, an example of this could be bakers who work in a small bakery have had to self-isolate from their return interstate, and other employees at the bakery, the retail staff members, are unable to be usefully employed as they've just got no baked goods to sell. And then finally, an employer can only lawfully stand down its employees where there has been a stoppage of work that is outside the control of the employer. So the examples that I just illustrated before in terms of the local government restrictions with the local pool and government restrictions in relation to the local council pool, I should say, and also the bakery example, both demonstrate circumstances which are beyond an employer's control. Also note though that a downturn in work or demand for services can be a reason for redundancy, but in this instance not for a stand down. I've provided Mary's example here to for us to workshop this issue. Mary works in a gift shop in a shopping centre. There is no current government direction for shopping centres to close. Her employer advises her that she is stood down from her work due to the downturn in sales and because they consider that they are unable to accommodate the government's requirement of social distancing rules of 1 person per 4 square metres. Is this an example of when an employee can be stood down? Can Mary be stood down in these circumstances?
So if everyone could just press the button that looks like a hand if you think the answer is yes, A. So we'll see if those hands come up. Oh, yep, okay. Lots of hands coming up, lots and lots. All right, so thank you for that. I might just pop your hands down now and give the no's a chance. Okay, so if you think the answer is B, no, put your hand up now. We'll see those ones coming up. Oh, I'm not seeing, oh, no, just a couple. Yep, okay, a couple of hands coming up. All right, yep. So I think most people have answered A, yes. So Alu, over to you.
Yeah, so this is certainly a tricky situation, and as I said, we will see this this will be decided in the next few months when we see those cases come through. In this instance, it's actually not an example of when an employee can be stood down in the circumstances, because in this instance, so I say here, there's no current direction for the shopping centres to close, so the gift shop is still open. Her employer says to her that because of the downturn in sales, and remember, a downturn in work is not necessarily going to meet the requirements of a stand down. And also this reason of, oh, we don't think we're going to be able to accommodate the government's requirement of social distancing rules, of the social distancing rules, basically. So in that instance, we would say that that is not likely to meet those requirements. And we don't have the information here, but it's not clear whether Mary's employer took into account any other considerations such as redeployment or modification of her work hours, in relation to Mary's employment. In this instance, it may not be likely to be found to be a lawful stand down. That was a tricky one. So in terms of if Mary wants to bring any course of action in relation to this, there is a standalone clause, standalone section in which she can bring a complaint to challenge her stand down in accordance with Section 526 of the Fair Work Act, or if the relevant enterprise agreement or contract of employment applies, she can then apply for the Fair Work Commission to deal with it, to deal with a dispute pursuant to Section 739 of the Fair Work Act, and so that would be specified in that particular situation. So the Fair Work may deal with the dispute in the following ways: so by arbitration, or by conciliation, or by making an agreement, or expressing an opinion. In dealing with a dispute, the Fair Work Commission must take into account the fairness between the parties. For example, whether staff are being given as much notice as reasonably possible prior to being stood down. If Mary's stand down is unlawful, she may also have an unpaid wages claim. So she has 6 years to bring a complaint to the Federal Circuit Court or Magistrate Courts for claims under $20,000. And I've provided a link there to the Fair Work Ombudsman guidance for bringing an unpaid wages claim. If in this instance the gift shop goes under, she may be eligible for assistance from the Fair Entitlement Guarantee Scheme. Note that there is a 12-month time limit to apply, so she'd want to make sure that she is across that as soon as if that becomes apparent. And I've also provided a link there for any sort of further information. Prior to standing down employees or making an employee redundant, employers may have regard to the following, and this is by all means not an exhaustive list of considerations. Please note that these considerations may be relevant to whether an employee has considered, whether an employer has considered whether an employee can usefully be employed in the business, and in considering fairness between the parties in the context of a stand down. However, for redundancy, if the relevant consultation obligations exist, employees could have regard to these considerations. For redeployment, employers may consider whether an employee can be redeployed to another position or be redeployed to another related business, either on a temporary or permanent basis. This may involve consideration of the following: does a job exist or a position or other work to which the employee can be redeployed to? The nature of any available position, the qualifications required to perform that job, the employee's skills, qualification and experience, and the location of the job in relation to the employee's residence, and any pay and entitlements which are offered. If an employer has positions available, even at the lower level, and that the employee has the skills to perform, the employer should not presume that the employee will refuse that position. So I've just provided an example there from May's example. So she's working as a retail assistant at a post shop. Her employer lets her know that due to the increased demand in postal services, that she will be redeployed to assist with sorting mail and packages at the local distribution centre temporarily until the 30th of June 2020. For changes in roster or hours of work, employers need to consult with employees about any changes to their regular rosters or ordinary hours of work in accordance with requirements under the relevant award or enterprise agreement. Consultation must include information about the proposed change, an opportunity for employees to give their views about the impact of the change on them. So that could include any considerations relating to their family or caring responsibilities, and a consideration of employees' response to and a consideration of the employee's response to the impact of the change. In terms of employees who are covered by any relevant award or enterprise agreements, there may also be additional requirements relating to the change in rosters or hours of work, so also important to double check that. The reduction of hours of work for a permanent employee usually does require the employee's agreement. The Fair Work Commission recently have made determinations to vary the Hospitality Award, Restaurant Award and the Clerks Private Sector Award to accommodate flexibility during the coronavirus outbreak. So under the Hospitality Award, this allows for flexibility for an employee's classifications and duties, a change from full-time or part-time hours of work, and directions to take annual leave. So that might be instances where cafes are providing takeaway services and their waiters might now be providing deliveries locally instead. Modifications to usual work to comply with social distancing directions. So some workplaces may be able to make modifications to their workplace to comply with social distancing. For example, John works in a warehouse that supplies groceries to supermarket chains. His employer has made modifications to the workplace by using yellow marking tape on the floor to mark distances of 1.5 metres to indicate where employees can safely stand or use machinery on site to comply with social distancing directions. I've certainly seen some example of some people lining up outside bakeries with lots of marking tape on the floor for where people can stand. Working from home, so employees can, by agreement with their employer, work from home provided that the employee's duties can actually be performed from home. Do consider any relevant provisions in an award, enterprise agreement, contract of employment, and also workplace policy if directing employees to work from home. Flexible work arrangements and reasonable adjustments. So under the Fair Work Act, employees other than casual employees, but do note in some instances casuals may be able to request it if they work on a regular and systematic basis, and it's likely that their employment relationship can continue. So employees who have worked more than 12 months with their employer can request flexible work arrangements if they have a disability, are a parent or have responsibility of a school-age child or younger, are a carer, 55 years or older, are experiencing family or domestic violence, or provide support to a member of their household or immediate family due to family or domestic violence. Reasonable adjustments may also be provided to employees due to, for example, their age, disability, family or carer responsibilities, and under the requisite Discrimination Act. So here the Anti-Discrimination Act in Queensland, or any sort of relevant federal anti-discrimination laws. So I've just listed some examples there. Got another example for you. So in this instance, Tasman's school-aged children are on an extended school holiday break due to COVID-19 restrictions. She sews clothes for a local clothes manufacturer. She has requested reasonable adjustments to work from home, to bring her work sewing machine to her house, and to vary her start and finish times so that she can assist with homeschooling for her children. We'll look at Tasman's example again in a little while. Moving on from considerations, I wanted to draw your attention to the provision in the Fair Work Act, which in this instance specifically prohibits termination of an employee's employment due to a temporary illness or injury. So the example that I came up with in this instance was Ken works as a night fill restocking grocery shelves for a supermarket. He's developed mild flu-like symptoms with a temperature, cough and runny nose. He calls in sick and goes to the doctors. His doctor provides him with a medical certificate for a week to recover from his symptoms. He contacts his manager to let him know that he will not be coming into work for a week and will provide a medical certificate. Ken's manager says to him, "Don't bother providing the medical certificate. We have plenty of new staff coming on and we can't risk having you back if you have symptoms of coronavirus." Just take a sip of water before we go into options. And we'll look at Ken's example again in a minute. There are a few courses of action an employee may take if dismissed in a COVID-19 related situation. I'll firstly look at general protections provisions in the Fair Work Act. So employees are protected from adverse action taken because of a protected reason. I've just provided just some examples here. There could be other protected reasons that may be covered in this context, but I'll just go through a couple here. So firstly, workplace right. So for example, if an employee has made a complaint about the underpayment of wages or a change in their working conditions due to COVID-19 and they are dismissed as a result of bringing that complaint, discrimination, which I'll go through next, temporary illness or injury, as we just looked at in Ken's scenario, and undue influence or pressure could come up. So in this instance, an employer could be pressuring an employee to accept a change in working conditions in circumstances where the employer is not significantly impacted upon COVID-19 restrictions. Just this next slide just shows when adverse action can be taken by an employer against the employee. In this instance, there's no minimum employment period for a person to be employed to bring a general protections claim, and casuals also have coverage under these provisions. Please note when you do provide advice that an employee has 21 days from the date of termination of employment to bring this general protections complaint to the Fair Work Commission. So just looking at Ken again, so he has a general protections claim. Certainly his employer has breached Section 352 of the Fair Work Act, so dismissal due to temporary illness or injury, but also what can also be covered is also Ken's workplace rights. So he has a right to take personal leave for illness in accordance with the national employment standards, or also potentially under other industrial agreements, industrial instruments as well. However, if Ken was absent from work for more than 3 consecutive months due to illness or injury, or a total of more than 3 months over a 12-month period, and he only took unpaid leave or a combination of paid and unpaid leave, he may not be protected from dismissal in the circumstances. So let's hope he recovers after a week. For unfair dismissal, there are a few threshold requirements that need to be met before bringing an unfair dismissal complaint. So there is a minimum employment period that an employee has to complete. So 6 months or 12 months if an employee is employed in a small business. So that's a business here that have less than 15 employees. Employees who are covered by a modern award or enterprise agreement or earn less than $148,700, not including superannuation, are able to bring a complaint. That figure of $148,700, that's the high income threshold. Now that changes every year, so that's the current figure as until the 30th of June. So double check after that date from the 1st of July what the revised figure is. For an unfair dismissal claim, an employee must be dismissed by the employer, and the dismissal was harsh, unjust, or unreasonable. There's a lot of cases that consider what is harsh, unjust, or unreasonable. I would recommend looking at the unfair dismissal benchbook, which is available on the Fair Work Commission website, which provides plenty of examples of when dismissals are for any of those reasons. And the dismissal was not consistent with the small business fair dismissal code, if that applies for small people who are employed by small business. and the dismissal was not a case of genuine redundancy. We've got another scenario for you guys to participate in. So this is Kim, who owns a fine dining restaurant. The restaurant usually provides a lunch and dinner dine-in service. Due to the government's direction relating to non-essential services, Kim briefly considered whether they should provide a takeaway service instead. However, due to the significant downturn in customers, Kim decides to close the restaurant. She lets her staff know that she is letting them go. Is this a case of genuine redundancy in the circumstances?
Okay, thanks, Alu. So again, if you can press the button that looks like a hand, if you think the answer is yes or A, we'll see those hands come up. All right, plenty of yeses coming through. Oh, heaps of yeses, maybe about 50 or so. So put your hands down now, thank you. If you think the answer is B, no, put your hand up now. All right, so it looks like that's the other half of our participants, or maybe just under half. So again, the yeses have it on this occasion. I'll just pop your hands down and hand back over to Arlo. Thank you.
Thank you. And that really does demonstrate that these issues are really tricky, and that it may not always be clear on the face of things. So in this instance, I don't actually think it's a case of genuine redundancy. And while I do agree that in terms of, because of the downturn in customers, that could be a reason to move towards a redundancy. But in this instance, it doesn't appear that Kim has met the consultancy obligations under the relevant award or enterprise agreement. So in this instance, these employees could likely be covered by the restaurant award, which has the consultation requirements for major change in this instance.
Okay, seems like we might have just lost sound, Alu. So if you can hear me, let me know. I might just see whether we can get things sorted out. Just pause for a moment there while we're hoping that the sound comes back on for everyone.
I think my connection's been restored. I'm not quite sure what happened there.
No worries. Thanks, Alu. You're back online, so thank you.
That's okay. What was the last thing you could hear me say just before?
So it sounds like, I think Kim didn't consult with the employees as per the award requirements.
Yes, yes, very, again, I'm not trying to trip anyone up in these sorts of scenarios. These are challenging issues, which is why it's really important for people to get advice in the circumstances. So for discrimination, if an employee may bring a discrimination complaint if they are dismissed because of an attribute. So say, for example, their disability or impairment, or due to family responsibilities in the area of employment. Note that a redundancy process may use a discriminatory basis for choosing people for redundancy. For example, persons who have family responsibilities are not chosen for redeployment. In this case, the process of selecting employees to be made redundant is not considered for an unfair dismissal complaint, but may be raised in a discrimination complaint instead. So possible avenues of complaint if an employee has been dismissed because of their attribute. But some possible avenues of complaint is a general protections complaint involving discrimination under Section 351 of the Fair Work Act. And again, that's a tight time frame of 21 days from the date of termination of employment. Or a discrimination complaint to the respective federal or state human rights commissions So a complaint to the Australian Human Rights Commission, so that could be, that should be made 6 months from the date of the discriminatory conduct occurred, or a complaint to the Queensland Human Rights Commission, so that's 12 months from the date of the conduct in that respect. We'll look at Tasman's scenario again, and I've added a few more details for Tasman's situation. So here, Tasman's, so she had previously, as you may recall, she had requested flexible work arrangements or reasonable adjustments to be able to work from home, and that's bringing some equipment home and also varying her start and finish time so that she could be at home with her children. So I've added this additional information in green. So Tasman's employer refuses her request for flexible work arrangements or reasonable adjustments because they say that SOIs have to work on site and they are unable to supervise her if she is working from home. Her employer has told Tasman that if she is unable to come to work, they will have no choice but to terminate her employment. So in this instance, Tasman comes to you for advice. I won't let you work through the problem in this instance. It can be quite complicated, but I'll present what these options could be in the next slide. So in Tasman's scenario, she could have a range of different recourse available to her. So if she is dismissed from her employment, she may have recourse to a general protections claim. So her adverse action claim in this instance would be a breach of her workplace rights. So she, in this instance, if she's requested it in accordance with requesting flexible work arrangements under the Fair Work Act, that would be grounds for that adverse action claim, and also a discrimination claim in this instance on the basis of family responsibilities. Or a discrimination claim in the respective Human Rights Commission. So that would be discrimination on the basis of family responsibilities in the area of work. If Tasman feels like if she's not yet dismissed, but she feels like she has no choice but to resign from her employment, she may decide to bring an unfair dismissal complaint. So she has 21 days to do that from when she decides that she can no longer be at work. So while Tasman may have a few options available to her, she can only bring one complaint based on the same facts and circumstances. However, depending on what happens to Tasman here, so whether she's dismissed or feels like she needs a constructive dismissal here, like she has no choice but to resign, she may have two separate causes of complaint. So one in relation to the feeling like she has no choice but to resign, an unfair dismissal complaint, and a discrimination complaint relating to not providing her those flexible work arrangements or reasonable adjustments for her to be able to work from home. From a practical perspective, the Fair Work Commission or Human Rights Commission, depending on where she lodges first, most likely to the Fair Work Commission, may wait till one complaint has gone through the process before deciding to continue with the other complaint, or may not decide to deal with it, depending if one complaint has substantially dealt with the same facts and circumstances, but this is quite tricky. So working through those issues can be difficult. So again, a range of options, and so very important for people to get advice if they find themselves in that situation. For support from employees, there's a whole range of support, local through to state and federal, that are available to people, but I just wanted to just draw your attention just a few resources which might be useful to pass on to any clients. So the National Debt Helpline can help with any sort of emergency relief or issues in relation to Centrelink, which is now Services Australia, and maintaining any rent or mortgage repayments, which is very likely to come up part and part with people who've lost their job. and accessing super and all of that. So certainly encourage people to speak to the National Debt Helpline for more for assistance in relation to that regard. Of course, if clients are experiencing any mental health issues, to direct them to the usual providers such as Beyond Blue or Lifeline, but I've just provided here some specific mental health information in relation to COVID-19 support. So what the government is providing there, I think options in relation to telehealth and all of that, so that might be useful. Also, some clients may have either related or unrelated to their issue that they've come to you in relation to the termination of their employment, some issues relating to needing to cancel any planned holidays, or what to do with their gym membership. So the ACCC has provided some really useful consumer guidance in that respect. For useful links, I very much encourage everyone to keep updated, or even I've now bookmarked the Fair Work Ombudsman COVID-19 guidance. That is updated regularly and will be updated especially today, because we're expecting that the JobKeeper legislation will go through. So that's the government announcement for support for employees during this time. And there's further information I've popped there. The Treasury website has a few fact sheets in terms of who would be, what employers and employees are eligible, what requirements they need to meet to be eligible for the job seeker payment. There's a few specific requirements there. For job seeker payments, that's for people who've lost their jobs. That was formerly the New Start payment. So there's certainly information from Services Australia that can assist there. And the Community Legal Centre Queensland has put together some coronavirus resources, done an amazing job to pull lots of fact sheets that have been collated by other community legal organisations and others. So there's specific information there as well. I apologise again for the technical issues that we have. I can see that we don't have a full house as we did earlier, but thank you to those who've logged back in and stuck with us. I certainly am happy to take any questions for the next few minutes. If anyone had any questions or wanted to go through a fact scenario again, let me know. Thank you all.
Thanks, Alu. And just a reminder that there are two ways you can ask questions. So the easiest one is to type your question into the chat box on GoToWebinar, and we'll see the questions come through. We did have a couple of questions come through earlier, so I'll try and recall what they were, because I don't unfortunately have access to them anymore. The other way you can ask a question is to pop your hand up on the GoToWebinar panel, and we'll see those hands come up and we can unmute you so you can verbally ask your question if you've got access to a mic. So Alu, I think the first question, and there are some coming through now, which is fantastic. So I'll get to those in just a moment. Matt, I think you, oh yes, okay. Matt had a question earlier, so thank you for repeating that for me. So Alu, is there a default stand down period in the legislation?
No, there's no default stand down period in the legislation under the under those provisions in the Fair Work Act. There's no prescriptive amount of time for stand down. No.
Okay, so people can be stood down for an unlimited sort of period, or a long period, or
when the employers are usually directing people for a period of time, as we can see. Say, for example, the Maya example, they've provided a specific date in April, but it could be that some employers might say that they can't actually, and reasonably sometimes may not be able to give them an end date. But importantly, people who are stood down, their employers should be in regular contact about, in touch with them about, say, for example, whether about the JobKeeper payment, or like how the business is going, touching base with them as to when it could be likely that that's lifted. And it could be that some places, like say for example for Qantas, like if flats are grounded indefinitely, they're not going to be able to give them a time frame, unfortunately.
Okay, that's great. Thank you. So the other question I think that came through earlier was in relation to one of the scenarios where the worker was given a lower paid role, and I believe it was around if that sort of situation occurred, so they couldn't do their regular job, but they were able to do some other kind of job within the workplace that would usually be paid less. Would that worker remain on their current pay, or would they have to take a reduced pay for that period?
In that instance, they might be temporarily taking a reduced pay if they're doing alternative duties. So also encourage, if that is the relevant situation, to have a look at that respective employee's award or enterprise agreement, because there might be particular directions in relation to change in duties or hours of work. Like I pointed out a bit earlier, that there are those determinations under a number of the awards where a lot of employees are quite heavily hit. So that's in the hospitality, clerks and restaurant industry. So there might be guidance in relation to what happens in those circumstances. Yeah.
Okay. Are there any other questions that anyone would like to ask while we've got Alu
Or
on
any
the
feedback?
line?
Was it too example heavy, or I wanted to include a few examples just so you could see how this may come up in the context of your practice, or if you know anyone that this might happen to. So any feedback is also welcome.
Great. We've got a couple more questions coming through now, all in a rush, as it usually happens. So I'll firstly go to Caitlin's question. So, not a question, but appreciated the examples, which is great.
Thank you.
Nathan, though, has asked, what happens if a stand down becomes a redundancy?
Yeah, really good question. And there might be actually, in some instances, where it's actually more appropriate to make someone redundant instead of standing down an employee, and some employers may take the stand down route to avoid paying those entitlements. So that can come up actually early on, but absolutely that's right. It could be initially that an employer might be able to stand down employees for a short period of time, but then their business might become not viable. So then they should follow if there's those consultation obligations, follow those requirements for consultation, taking those steps prior to making any decisions to make those employees redundant. Or there might be instances where companies, and we have seen recently with some companies, have completely folded. So some people have been made redundant through that process, and not necessarily having a stand down process beforehand. But yes, it can come up. Initially, we've seen instances where people have been stood down and they possibly should have been made redundant. But it also, yes, absolutely can happen at a later stage too.
Okay, so there's some other comments here saying that the examples were great and that the presentation was really useful. Yeah, some thank yous coming through, and correction of misconceptions, which is absolutely what we want, and that's really great feedback. Thank you, everyone, for providing that. We might then wrap up today's webinar. If you do think of any other questions later, feel free to email them through to me, and I can pass them on to Alu for a response. But otherwise, do check out the links that are on the screen at the moment and in the handouts. We'll pop those links and the recordings for both parts of today's webinar up onto the website later this afternoon. Now, someone's just popped their hand up, so I'll just see whether there's a question there. Did you have a question, Duong? Or was that just raised for an accident? Accidentally raised? No, okay, don't think there is a question there. So I think that's all that we'll deal with for the moment. So please join me, everyone. A virtual hand clap for Alu for bearing with us and through the tech difficulties this afternoon, or this morning, I should say. I think this is just part of how life will be for now.
The benefits of working from home, yes.
Yeah, so thanks for hanging in there, and thank you for sharing your knowledge and your thoughts in this really difficult time around employment law issues for consumers.
Yeah, thank you. And thank you everyone for your participation. And as you can see, these are not easy issues. So go easy on yourselves and stay safe during this period.
All right. Thanks, everyone. We'll see you next time.
Thank you. Bye.